What I would like to say by way of introduction is that my report overlaps with parts of Elmin's report and her team's work. So I will gloss over certain issues because I think it's not necessary to belabor some of the issues. And I only want to point out some of the sort of interesting or important aspects that emerge from the case law and from other developments. Now, in the first slide, I want to start with the statutory framework and the legal foundations, just to point out some of the issues that developed over time. We will know that initially there was a discussion about whether the government should have acted in terms of the DMA or in terms of the emergency powers under the Constitution. Now, as Almin has pointed out, that matter has now been solved by case law, and we have now legal authority on the fact that the DMA was, in fact, the most appropriate act at the time, and given the context of the issues that government had to deal with. So related to that issue, whether the DMA was, in fact, the most appropriate piece of legislation, there was also the Helen Suzman Foundation case, which took the point to court, namely that DMA should only be used as a temporary measure, and that while government must exercise its constitutional legislative duty to adopt legislation for the pandemic itself. Now, I think that case was interesting initially because to put things in perspective concerning what government powers are in this context and whether the DMA is the sole piece of legislation that could be used. The application was unsuccessful, and I think the reasons provided by the court in the matter are sound reasons. Because the so-called temporary nature of the DMA was first and foremost not supported by the legislation itself or the wording in the DMA. So I think the argument was bound to fail on that point. Then also concerning this first issue, the National Command Council matter was, I think, controversial right from the beginning. And I'm not going to say much about it except to stress the point that we have now clarity from the ESO case that the establishment of bodies of this kind falls within the powers of the executive and the discretionary powers of the president. And I think the reasons provided by the case for that outcome are also sound. I also think there is one issue concerning that case, which I think we should take note of, and where I think the court has gone wrong. And it deals with the decision that was taken by the executive in the establishment of the council. When the case was brought to court, various attempts were made by the applicants to get hold of a sort of written proof of the decision that was taken. And the government response was that there is no written decision available. And they explained that by saying that the normal executive council processes were followed and that this decision was taken collectively by the members of the executive. Now, the court reasoned that it was not necessary to provide the decision that the applicants wanted to have because of the confidentiality rule that covers the dealings and the affairs of the executive under the Constitution. Now, I think it is this point where the court had applied the wrong analysis. The confidentiality rule only applies in the case of the deliberations and the processes followed. Once a decision has been taken, it stands as a collective decision of the council, of the executive, and anybody who needs that decision for the sort of assertion of rights and interest will be entitled to have access to that decision. So I think the court misinterpreted the confidentiality rule in this instance, and it is actually, I think, it would have been very helpful if that decision and its wording could have been provided to the public or whoever needed it at the time to establish what the decision was actually about and the nature and scope thereof. Then another issue that was also raised in the under the initial issues concerning the foundation and the statutory framework is the challenge to the ministers, to the Act itself. I'm not going to deal with that because in the De Beer case, the Act was found constitutional, and the application failed to decide on its unconstitutionality. But a more interesting issue was the minister's declaration, which was also challenged in the De Beer case.
Prof. Strydom, I want to check if you wanted to move the slides because they are.
I asked the admin to move it for me today. I'm still on the first one, by the way.
Great, thank you. Sorry for interrupting.
The minister's declaration was challenged also, and I want to point out one issue. I think that was also, of course, unsuccessful, but in the course of the judgment, by way of remark in passing, the court pointed out that the minister's declaration was published at the same time and in the same government gazette as the classification of the event as a national disaster. And the issue why this was raised, or the reason why this was raised, is because there are different grounds for classifying an event as a national disaster and compared to the declaration which falls within the powers of the minister. And this is maybe something that can be taken into account in future cases. So it raises the question whether the minister applied her mind independently of the body that was responsible for the classification. If so, it points to the accountability of the minister because she was bound in terms of the Act to provide the reasons for the declarations, which could not be the same reasons that would apply in the case of a classification. But the matter was not decided because it was merely raised as a sort of point in passing. But I think it is an important issue because it deals with the different roles of the two bodies or persons responsible for classification and for declaration, respectively. Right, we can move now to the second slide, which brings us to the issue concerning the regulations and the challenges there too. And here I just want to point out to a trend that seems to be unfolding if you compare the earlier cases with the later ones. In the first cases, there was a sort of very strong emphasis on applying a rationality analysis, which I described as the low threshold which government must comply with. Now, in both the De Beer case and the ESO case in the court a quo, the way in which this rationality analysis was applied was somewhat confusing. Because if you read some of the remarks by the court, there is not only an emphasis on the rationality requirements, but also on the requirements in terms of Section 36 of the Constitution, which deals with the limitation of human rights and fundamental freedoms. And it is rather confusing how the court dealt with this, and the same applied in the case of the ESO case, where the applicants relied predominantly on the DMA to argue for an irrational point on which they based the application before the court. But in some instances, they also moved over into a Section 36 application. Now, the consequence of all this was, first of all, that in both cases, there is some confusion on which was applied eventually, but I think to be more fair to the outcome of the case concerning what analysis was actually used, I think we can safely say that in both cases, the rationality test was applied. Now, as I've said, that is a very low test for government to comply with. If you look at the later cases, the fair trade case and the British tobacco case, there is a definite move towards applying a fundamental rights analysis, which is a higher threshold to be complied with. And I think the court has also very emphatically, especially in the British tobacco case, made the point that the kind of challenge that we are facing here when we deal with the constitutionality of the regulations should be dealt with in terms of the human rights provisions and especially Section 36. Now, if that is going to be the trend in future, and I think it will be, the government has a sort of greater responsibility to assess the consequences of its measures, which is a test to be met that is fundamentally higher than the rationality test. And I think that is a sound development because many of the measures, as we know, impact quite severely on human rights and interests. And in terms of Chapter 2 of the Constitution, Section 36 will then be very relevant to decide on the constitutionality of the measures that government has decided on. Then I move to the next slide, which deals with the specific human rights issues, and I will be very brief on that. I just want to highlight a few points. The first one deals with access to social assistance, which became a relevant issue in the Scalabrini case, where certain groups of refugees and permit holders were excluded from social assistance. And the reason why I want to point out this case is because I think this case should never have gone to court. It should have been settled out of court, and applicants have made a severe or a serious attempt to settle the matter out of court, but it was unsuccessful. The reason why I say it shouldn't have gone to court and should have settled out of court at least, or at the most, is because of the fact that the legal position was clear at the time, constitutionally and in terms of case law by the Constitutional Court, that kind of exclusions of certain groups is unconstitutional. And secondly, the sort of acts that applied to the issue of social grants or social assistance was clear on this point, that the applicants in question here were entitled to apply and receive the kind of social aid that the government provided in terms of responding to the pandemic. The second issue, very briefly, the race-based access to financial aid. We have the two cases there listed in the chapter. The Democratic Alliance case and the Solidarity case. The importance of these two cases, especially the Democratic Alliance one, is that it places an obligation on government to provide some kind of a weighting explanation where different factors are taken into consideration in deciding on who should be entitled to this kind of aid. In the Solidarity case, that was not taken into account by the court, and I think the matter was properly remedied in Democratic Alliance case, where it is now clear that the government has an obligation to tell us so that those who need to apply also know what the position is, how one one factor weighs against the other, so that we have clarity on how government's decision in this regard will determine the outcome of the aid. Okay, let's now look at the enforcement brutality during the lockdown, and maybe I should also link that up with the police misconduct issue, which forms part of my chapter. As far as the brutality during lockdown issue is concerned, I have listed two incidents, both involving the South African National Defence Force. The one, of course, is the notorious Xhosa matter. This matter went to court because the applicants in this matter applied for a long list of remedies from court, which I have to stress were awarded. But I think the case is important for other reasons as well. Once that it showed the sort of inadequacy of the investigation by the South African National Defence Force into the matter. And also, I think it points to almost a dismissive attitude to the issues involved. So that, I think, is important to take note of, also because there are other cases where we have a similar development, and I've listed the incident, which was reported on very recently in the media because of the fact that there's no response forthcoming from the South African National Defence Force on how far the matter has developed. And it's the same in the Xhosa case. I myself tried to get information on where we stand with this case, and I'm still haven't received any response to this. And the second case I'm talking about also took place early in 2020. So it's more than a year ago, and one would have expected that in important matters of this kind, there would have been some kind of a clarification to the public, especially to the victims and their relatives and family and so on. I think this is something that should not be allowed to happen. And let me also point out the second important aspect of this case. In the course of the proceedings, the courts drew on reports by the Human Rights Committee of the United Nations, where some time ago already the report by the Commission has pointed out the sort of dysfunctionality that we find both in the case of the military ombud as well as in IPID for very various reasons, a lack of capacity, a lack of resources, and other issues, which inhibited the effectiveness with which these two bodies can investigate violations of this kind. Now, the other worrisome aspect of these reports of the Human Rights Committee, since they have been published and provided to government, very little, if anything, has been done in order to remedy the situation. And we have seen this also in the committee reports, parliamentary committee reports, where IPID has appeared to explain certain developments during the COVID pandemic, and especially with regard to the investigation of cases and the outcomes. And if we read the responses by the parliamentary committees on this score, the shortcomings that we still experience for several years now still persist. And one would hope that there will now be some greater urgency to deal with this more effectively, and to provide the two bodies with the necessary assistance to make them more effective than they are at the moment. The last bit of the report deals with the corruption issues that emerged some time ago, many of which are still emerging. And I think we all have taken note of the report by the Special Investigation Unit of the nature and scope of the corruption. I think it is important to follow for the next phase, which we'll start working on soon, I suppose. How many of these cases will eventually go to court, and what will be the outcome of the investigations concerning this phenomenon, which I have to add was of main concern for the president himself when this emerged. And I also want to draw attention to the fact that the African Union has also, not the African Union, the African Commission on Human and People's Rights has also reported fairly recently about this phenomenon that has become fairly widespread in many other African countries. And I think this is something for the future to be taken into account when we move forward. Thank you.